Okay, as promised, next up is abortion, which, as I mentioned in the last video, is a substantive due process right, but it gets its own rules, as you know. So here's a handy checklist for you, right? Again, as we go through these videos, I want you to think as we do each one of these, right? As we talk about every item on this list, is this something I understand thoroughly that I could, right? I could teach to my dog or my kids or my spouse or whatever the case may be. And you want to be at that point with every one of these, right, items, and then you're good to go. So, first of all is the point that it is a substantive due process right. So you don't do any kind of enumerated rights analysis on this. You don't do an equal protection analysis on this, right? And the reason that's important is because you can be asked, and I've seen bar exam questions where what they ask you is not to do an analysis on an abortion case, but simply what clause, right, applies when it comes to evaluating the issue of abortion. So you need to know that if it's a state restriction on abortion, it's the 14th Amendment due process clause, right, under which right, courts would evaluate the case. And if it's the federal government acting, obviously it would be the Fifth Amendment's due process clause, but so it's important to know that it's a due process issue. You can be tested on that. Next. You need to appreciate and distinguish between, right, the core holding of Roe versus Wade and the trimester framework, because one of them survives and one of them doesn't. So you want to be able to speak about this in the language of lawyers, right? And what lawyers say is that the core holding of Roe has never been overruled, right? The core holding of Roe still stands. And what is that? The core holding of Roe is that a woman has a right to terminate a pregnancy, right, at certain points early in the pregnancy, right before viability. That is the core holding of Roe. The government, the U.S. government and many state governments have repeatedly asked the court to overrule that. The court never has overruled that, but it has gotten rid of the trimester framework, which, as we discussed in class, was not workable. You need to be obviously very comfortable with the Casey case, not only the rules out of the Casey case, but the laws that were upheld and the laws that were struck. You have all that written down in handouts. I'm not going to repeat all of that. But Casey is where the court moved away from the trimester framework, right, and toward what they call an undue burden, which they defined as a substantial obstacle placed in the path of a woman who wants to have an abortion, right? Now that undue burden standard applies pre-viability. And I want to emphasize this point one more time. If you have a restriction that applies to all abortions, right, then obviously that also is a pre-viability restriction, because by definition, all abortions includes pre-viability abortions, right? So under Casey, you have this one set of rules, right? Pre-viability, so that V is the only thing left, right, on the continuum of pregnancy. There are not two lines, there's only one. As to post-viability, right, the government can regulate up to and including a ban on abortion. So we'll get to that. You see that's actually enumerated on this list here, so I got ahead of myself, but that's all right. Casey, so you need to know Casey. Number 4, Hellerstedt. So you see how this builds, right? The central holding of Roe still exists. Casey changed from a trimester to the undue burden, and Hellerstedt defined undue burden, right, and you know, kind of tweaked it, so that now we know that the undue burden test is a balancing test, right, that weighs the burden on the woman against any potential benefit that results from whatever restriction it is. And most of the time there, it looks like we're talking about medical benefit. So there's your trio of cases. And again, if you look at Roe, you look at Casey, and you look at Hellerstedt, and you didn't immediately know what that case was and what it did, you need to bone up on this. I wrote number 5 here, analogical reasoning, as something to keep in mind when you're doing studying abortion, and something that should be on your checklist. Because you have, I just mentioned this earlier, you have these actual examples from both Casey and Hellerstedt, right, of laws that were upheld and laws that were struck down, right? And so you want to, again, be very cognizant of those so that you can compare, or anytime you see an abortion question, right, where there's a certain restriction, you want to be able to compare it, right? Is it comparable to the laws that were struck down, like spousal consent, right? Or admitting privileges, or surgical facility requirement, right? Is it comparable to that, or is it comparable to laws that were upheld, like the 24-hour waiting period and things like that? So analogical reasoning is especially important in these abortion cases. As I mentioned earlier, post-viability rules, right? You need to know the post-viability rules, and that includes number 7, right? The exception to the exception. right, for a dilation and extraction. So basically what a state can regulate up to and including a ban on abortion procedures post-viability, but it must have an exception for the health of the mother, not just the life. Keep that in mind, please, not just the life, but the health of the mother. The only exception to that is dilation and extraction, right, where the court said there was no evidence in the record that that particular procedure is ever necessary to preserve the health of the mother, given the availability of other procedures. A couple of bright line rules to know in the abortion cases, right? Judicial bypass, you need to know what that is. Hi, Lainey. Right, and that a law that restricts access to abortion for minors, right, and by requiring parental notice and consent, that kind of a law would be upheld as long as it contains a judicial bypass, which means a way for the minor to go around parents that are incompetent or abusive, right, and get an order from a court. And finally, number 9, that the government, although it is not supposed to interfere with a woman's right to terminate a pregnancy pre-viability, right, without undue burden, is not required to help a woman get an abortion. So again, as with all these videos, this is a nutshell time, right? But I want to provide a resource where you can just look at this list, and again, if you're really comfortable with everything on this list, then you're good to go as far as abortion is concerned. If there's anything on this list that you are not comfortable with, then you need to get back to work and do some reading on it. So, as always, be well, stay safe, and stay tuned.